My lord, so last submission, my lord. Just one word, my lord. Section 12, Schedule 5 and 7, in my opinion, should be kept away while deciding this matter, my lord. This is a matter which is going to decide a system which is going to test the arbitration clause and its validity. My lord, that is a post-appointment system. That post-appointment system prescribes 19 items in the Schedule 9 and 34 items in Schedule 5. They are only an opportunity for the parties to know about their personal connections. So that is a different issue that should not be kept in mind while deciding this. Here, my lords are going to decide the validity of a clause or a system which will ensure neutral arbitration. Lord.
Thank you so much, Mr. Ravi Shankar. Mr. Rohan Kalwar.
My lords, I'm going to address my lords firstly on a proposition which has not been discussed, which is the skewed incentive which arises in unilateral appointment procedures. My lords, on two stakeholders. One is the appointing authority.
So you're saying skewed incentive?
My lords, in cases where there are unilaterally appointed panels or unilaterally proposed panels. My lords, firstly, qua the appointing authority, anyone who is going to be rendering a verdict in their favor, there is a perverse incentive in economics which is called to reappoint that person in the panel. And my lords, it's a known thing that panels are reviewed periodically and thereafter curated. My lords, the second skewed incentive is of the arbitrator in this case, who, my lords, has an incentive to remain on this panel. So, my lords, what would happen is that
what is the first skewed incentive?
My lords, of the appointing authority, that if I'm an arbitrator and I give a judgment in favor, let's say, of the appointing authority, I'll be reappointed.
And there is no provision in the Act which bars reappointment in more than one arbitration.
Absolutely, my lords. My lords, there may be cooling
beyond 3 times.
Beyond 3.
And
Schedule 5.
my lords, here, so
Schedule 5 item. Schedule 5 is it? 5 or Schedule 5? Previous services. Item 20.
20. Yes, 20.
Data has within the past 3 years served as been appointed as an arbitrator on 2 or more occasions by one of the parties or an affiliate of one of the parties.
my lords, however, this is on the point of impartiality at the stage where I'm questioning the appointment. I'm saying that in a year.
So in 3 years, you can't accept more than 2 arbitrations from one party.
My lords, however, if I'm to be.
Therefore, it's clear in a case where you come across a situation where a person in the panel has already been appointed twice, you would say that you can't appoint him at all.
My lords, firstly, these aren't disclosed.
Different from what's being argued.
What one more thing was saying after.
Repeated.
My lords, I will only pick a person, even after the scope of 3 years, who has decided in my favor. And within those 3 years, I can repeatedly appoint up to twice for someone who's decided in my favor. This is qua the appointing authority, let's call them railways. Qua the arbitrator also, my lords, a perverse incentive is to remain on this panel. And my lords, I may be on several panels. I may duplicate my appointment, and therefore this perverse incentive, in fact, is recognized in a judgment, my lords. It's by the name of Hooters of America versus Phillips. It's at page 3585 of volume 3, my lords.
Hooters was actually referred to in that judgment which was cited by Mr.
My lords, Mr. Banerjee also referred to it. There's just a sentence there which I want to refer to, my lords. So here also there was a panel.
So what they have held, they said that such person is ineligible to be appointed.
My lords. And there's a very interesting sentence, my lords, just falling from what my lords said.
Read.
My lords, I'm at page 3589, relevant. The appointment procedure is the employee and Hooters each select an arbitrator, and two arbitrators in turn select a third. Similar to core, similar to my case as well. My lords, the bottom of that paragraph, fourth line. Further, nothing in the rules restricts Hooters from punishing arbitrators who rule against the company by removing them from the list. Given the unrestricted control that one party, Hooters, has over the panel, the selection of an impartial decision maker would be a surprising result. My lords, this is one incentive I wanted to.
Interesting. So within a period of 3 years also, you appoint an arbitrator on a second occasion.
Absolutely.
And once, even after the period of 3 years, the bar of 3 years is expired, you'll have an eye on who held in your favor in a previous arbitration. That's your point.
3 years may be a cooling off period, but after that, as my lords are saying, I'm aware who is decided in my favor.
So therefore, in the new proposed amendment, exactly this is what it is. The proposed amendment says that we will now have, instead of a prohibition, a cooling off period.
Apologies, my lord, I couldn't.
There's a cooling off period suggested by
My
the new
lords.
panel.
And my lord, the second point I want to raise is regarding the legislative infraction. What is exactly prohibited under this act? My lords, I want to read a sentence at the cost of repetition in TRF and one sentence in Perkins. If my lords may have page 1033 of TRF.
What do you want? Was the submission?
My lords, the submission is that there is a implicit legislative bar arising out of the fact that an individual who has an interest in the outcome of a dispute cannot be made the appointing authority.
That Mr. Paul argued.
My lords, just a sentence to show where is this coming from legislatively. What is the statutory bar here, which these two decisions in my respectful submissions have addressed already. My lords, at para 57, 1032 bottom, in such a context, the fulcrum of the controversy would be, can an ineligible arbitrator like the MD nominate an arbitrator who may be otherwise eligible and a respectable person? As stated earlier, we are neither concerned with objectivity nor individual respectability. We are only concerned with the authority or the power of the managing director. By our analysis, we are obligated to arrive at the conclusion that once the arbitrator has become ineligible by operation of law, he cannot nominate another as an arbitrator. And I'll end at the next sentence. The arbitrator becomes ineligible as per prescription contained in 12.5. Now, my lords, this is interpreted in Perkins and without apologies. My lords, this next sentence from Perkins is at 1274, my lords. I'm reading paragraph 16, where they interpret what is this I'll just read that sentence. The ineligibility referred to therein was as a result of operation of law, in that a person having an interest in the dispute or in the outcome of a decision thereof must not only be ineligible to act as an arbitrator, but must also be eligible to appoint anyone else as an arbitrator. My lords, at the foot of this paragraph, that has to be taken as the essence of the amendments brought by the Arbitration and Conciliation Amendment Act 2015. Independence, my lord said, is a complete virtue. It can't be negated at margins. So, my lords, if independence has to be seen as an absolute virtue, this amendment introduced independence and impartiality. What my lords have said in Perkins is that the essence of this amendment is that an interested party cannot adjudicate. If an interested party cannot adjudicate because they have an interest in the outcome, they cannot nominate. Now, whether I nominate 1, 2, or 100 is immaterial.
Thank you. Thank you, Mr.
My lords. Obliged, my lords.
Now,
It
Mr.
is-
Anirudh, yes.
Keep it extremely brief, my lords. My lords, I locate impermissibility under 3 heads. First, Section 18 of the Arbitration and Conciliation Act. Second, Section 23 of the Contract Act. And third, where there's a state party involved under Article 14. Insofar as Section 18 is concerned, my lords, my note contains various references, a lot of which my learned senior Mr. Banerjee has already referred to. But in substance, my lords, what Section 18 proscribes is the inequality in the process, including the appointment process. What it requires is absolute equality. And if absolute equality is not guaranteed at the stage of appointment, absolute equality is impossible during the process. Now, this, my lords, this equality is completely independent of independence and impartiality. Independence and impartiality is a separate paradigm covered by Section 12(5) and the 2 schedules. Equality, and when I refer to equality, I'm referring to the lack of mutuality in the appointment process. Any unfair advantage that any party has at the stage of appointment will result in a violation of Section 18. Let me give an example. There could be so many scenarios where the panel is perfectly eligible, but the party nominating the panel may fill the panel with arbitrators who have already decided a similar issue in their favor in the past. In such a scenario, my lords, there is no 5th schedule or 7th schedule violation, but there will still be a violation of right under Section 18, because why should one party have the right to fill the panel with people of their choice?
In fact, you're right. I asked a question in the morning. Are there any apprehensions or objections independent of the 7th schedule? And this is what you are saying, that you appoint.
And I can give a real life example. We did multiple arbitrations in relation to metro rail construction. There was one exclusion clause which was the subject matter of litigation in most of these arbitrations. Now, the first set, we had a completely independent panel. The second set of panels that were given to us comprised of only those who had interpreted that clause in favor of the Metro Rail Corporation. Now, today, if the Metro Rail Corporation has this unilateral power, it's independent of 5th schedule, independent of 7th schedule, but is it not a violation of equality under Section 18, I ask myself. This is the first point. Second, my lords, to answer a query that fell from your lordships is that this Section 18 is located under Chapter 5, which deals with conduct of the arbitration.
But does that not go to the panel as opposed to, the power?
Sorry, my lords?
Does your argument not therefore impeach the panel as opposed to the power to...
My lords, the panel is perfectly eligible because there is no question of subject matter. There is no entry relating to subject matter bias in 5th schedule and 7th schedule.
Well, really speaking, as no, it doesn't encroach, does not breach any provision of the statute.
It doesn't breach any provision of the statute, but the panel comprises of only those arbitrators who have decided the very same issue in favor of the party appointing the panel. That's the reason why, my lords, even though party autonomy is important, party autonomy has to be balanced with. Sorry, my lord.
As against each of the arbitrator who had decided similar cases against them.
They have only decided one such case, but that's enough. They have not decided more than two, so therefore fifth schedule will not come in. So today there is no grievance against the individual arbitrators, but it is that party that has filled the panel with persons who have already decided the issue in the past. A party should not be permitted to weaponize the appointment process.
Party autonomy cannot be for one of the party, but party autonomy has to be mutual for both the parties.
And I go down, my lords, and party autonomy has its limits. If there is a mandatory provision of law, such as Section 18, party autonomy would give in to such a mandatory provision, because having a blemishless process is an equally, if not more important consideration. Today, your lordships has laid down the law in relation to minimum judicial interference. Why? Because it presumes that the regime is blemishless today, because of the fifth schedule, because of the seventh schedule.
Blemish. In TRF, they mentioned that we are not concerned about respectively, right?
I go down.
So, the persons who have decided on a particular aspect in favor of the organization, they be more respectable.
I go back to what my learned friend argued on the incentives for appointment. Yes, my lords. Then, my lords, before I conclude, my lords, there is one passage, I don't think I'll have the time, but I'll only provide the reference to the drafting history. Some portions of the drafting history my learned senior read out, but at page 9823, volume 4, tab 135.
But you know, your point that, look, suppose they constitute a panel, and that panel only consists of people who have arbitrated in the past and say decided that issue, construction of a specific notice provision for termination favorably to that particular employer. Can you not raise a ground of challenge under 12A?
Because it's not any of the grounds contained under Schedule 5 or 7.
No, but 12A doesn't confine you to only the 5th or the 7th schedule. The 7th schedule. 12 says, such as the existence, either direct or indirect, of any past or present relationship with, or interest in any of the parties, or in relation to the subject matter in the disputes, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence or impartiality. So suppose a railways or any PSU appoints an arbitrator who has decided that very issue. All the arbitrators in the panel are people who have decided in their favor.
May I, two aspects.
This not be a ground.
First, I will never know as a contractor, because what needs to be disclosed would only be what is set out in the 5th schedule. So if this is not covered in the 5th schedule, so I will never know whether they have decided in the past or not. Point number one. Point number two, let us assume that they have decided the same issue, not in relation to the same metro rail corporation, but in relation to another public sector undertaking. Your lordship sees exclusion clauses in so many cases, so many government contracts.
You have decided the same interpretation.
Same interpretation. So why should one party have the benefit of picking?
There is an asymmetry of information according to you, because the contractor will not know everything about that arbitrator.
I bow down, my lord.
Or each of the arbitrators.
And my lord,
identifying the background, you'll have to engage a detective agency to find out the background of the arbitrators.
my learned senior also mentions that HRD Gale.
Same ground was rejected.
Where?
HRD versus Gale, the arbitrator had given a similar award earlier.
That was rejected.
Yes. So, my lord, the problem here is the process and not the individual, my lord,
Who's
arbitrator.
concerned?
That's the real problem.
My lords, then my lords, on the issue of whether, even though it is located in chapter 5, whether section 18 will apply to the arbitral appointments, my lords, there is one reference I would like to provide your lordships. at page 9823, volume 4, tab 135, which is part of the drafting history of the UNCITRAL model law. My learned senior read out certain portions. This portion also deals with it and specifically says that it will apply to the agreements between parties in relation to the procedure for the arbitration. And even when your lordship sees the scheme, even though it says conduct of arbitration, 18, 19, and 20 are prior to the notice of arbitration. 19.2 gives parties to agree upon the liberty in relation to the procedure. 21 gives parties a liberty to agree upon the place of arbitration. Therefore, when you look at the scheme, even though Chapter 5 deals with conduct, it begins with the agreement between parties on various aspects before going into 21, which is the commencement of the arbitration, and thereafter the procedures like pleadings, etc. in the arbitration. Therefore, my lord, the reading of the scheme, along with the drafting history in my respectful submission, would in my respectful submission make it clear that section 18 applies to the appointment process as well. This passage, my lords, is very, very clear. The passage that I just mentioned, I've referred to it in my note, my lords. I don't want to read it out because of the paucity of time. Finally, my lord, just one, before, if your lordships is to accept this contention that section 18 applies, there are various issues that will arise. What happens to arbitrations that have been concluded? What happens to arbitrations where the challenge is pending? Because section 18 was unamended, it will apply even in the pre-2015 era. Therefore, your lordships may consider using the power under Article 142 to restrict the applicability in a post-2015 scenario where a challenge has been raised and is pending before a court today. Because if it is going to apply across the board, it will second consequence. What happens if the offending portion alone is severed? Can the doctrine of severability and blue pencil rule be adopted, and can the court then go ahead and appoint an independent arbitrator? In this regard, my lords, if one party has provided consent on the basis that it has a right to unilaterally appoint or appoint a panel, that goes to the root of the consent to arbitrate. Therefore, in my respectful submission, the doctrine of severability and blue pencil rule cannot be read in because it vitiates consent in the first place. So if your lordship is to accept the section 18 argument, the arbitration clause itself goes, point number 2. Point number 3, who can raise it? Can today the party that has nominated the panel and thereafter lost in the arbitration go and challenge it saying section 18 has been violated? In my respectful submission, your lord, that the answer would be no, because in such a scenario, the right under section 18 itself would not kick in. Section 18 is a right that accrues for the benefit of the party that is discriminated against. Deeply obliged, my lord. There are a lot of foreign judgments and articles that I've referred to in my note. I don't want to go into all of them. Deeply obliged.
Lord, I will take 4 minutes exactly, since Lord, I appear for Shaparji Palanji, Lord, which is a contractor. We had filed an intervention, Lord, and mentioned yesterday. Lord, I've mailed my note to the court master, and very briefly, I've formulated my points over the lunchtime. Just get copies. But we are carrying the hard copies also, Lord. Lord, very quickly, my points.
The submission.
Lord, my submission is obviously to say that 4 points, Lord, I'm making. Section 7, which talks about arbitration agreement, does not include an agreement on who will appoint. It's only limited to intent to arbitrate. And I'll read section 7. Means an agreement by the parties to submit to arbitration. So once that test is satisfied, the second conditions which parties often put, that unless I appoint, only then I will go to arbitration. Or it can be only from my panel. Then only, that was a question that had come from Lordship in the beginning. What if it is a conditional arbitration clause? But the requirement of section 7 is limited to intent to arbitrate. Right to appoint or unilateral right to appoint or limited to panel of appointment has to be divorced from it. They cannot go together. Once the test of intent to arbitrate is satisfied, then law kicks in.
Yeah.
That's my first point, Lord. I put it in my note, submission number 1. Lord, intent to arbitrate has been recognized in the Cox and King's judgment, which on the group of companies doctrine. So that's my first point. Intent to arbitrate is the first step. As per 7, arbitration agreement has been defined to means an agreement so and so. It is not predicated as to who will have the right to appoint. Thus, existence of an arbitration agreement gets satisfied as soon as the requirement of 7 is met. Now, my second point is there are 3 aspects of constitution of an arbitral tribunal: intent to arbitrate, commencement, and procedure. These are the 3 aspects before a tribunal is in place. Now, 11.2 uses the word parties are free to agree on a procedure. Not actually, the main mischief is here. How much stretching do we give to the word procedure? Does it mean procedure in case parties fail to agree? Or would Lordship consider procedure to mean even determining who will appoint among the 2 parties? Procedure will only mean, my lord, methodology. The real problem is procedure, my lord. If Lordship gives interpretation to the word procedure in 11.2, the entire problem gets solved. That's the Gordian knot. Because that is where the agreement is referred to, which gets used. That, oh, I have a right to agree on the procedure for appointment of an arbitrator. That means I can decide who will be appointed as an arbitrator. My lord, my submission here would be, keeping in mind the mischief rule, Hayden's rule, purposive interpretation, the word procedure will have to be limited to mean in case parties fail to agree, then what is the procedure? Lord, that is what is the fallback also in 11.5, my lord. Then 11.8, which Mr. Banerjee had referred, my lord, has the words independence. And it also uses the word other considerations. Lordship had put a question, what is their other? Those other considerations would kick in because it's a very wide term. Lord, on section 18, my lord, I have referred to the judgment of PAM development, which had made section 18 applicable to even post-arbitration. And my lord, on panel, my lord, I have just 2 points to make. What cannot be done directly should not be done indirectly. If Lordship is permitting one party to appoint an arbitrator, then panel will be justified. But if one party can't appoint a sole arbitrator or the presiding arbitrator, then even panel cannot be justified. Lord, if 3 people cannot be appointed by 1 person.
So tomorrow we'll start with the arguments of the Solicitor General.
Lord, one request, Lord, my colleague says the intervention may be formally allowed, Lord.
Yes, we are allowing
I'm
it.
grateful.